Mr. Leonard has joined us.
Hey, Ms. Rowland. Morning, Mr. Leonard.
Hi. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3006, United States of America versus Issam Hussain Abu-Ghosh, also known as Isam Ghosh, also known as Issam Hussin Hassuna, also known as Sam Ghosh, Appellants. Ms. Rowland for the appellant, Mr. Leonard for the appellant.
Good morning. Ms. Rowland, you may proceed.
Thank you, Your Honor. Prior to sentencing, the judge directly linked answering the court's questions about other possible crimes to acceptance of responsibility, saying that this court will not tolerate his refusal to answer questions and will not sentence him until this is done, and silence is inconsistent with acceptance of responsibility. Even after the parties repeatedly explained the law, the judge kept going back to it. At the final sentencing hearing, he punished Mr. Abu-Ghosh more harshly for asserting his privilege. The judge said that Mr. Abu-Ghosh failed to comply with the court's order by doing an end run around pretrial services review. He actually said the probation office, I think that was a misstatement because the probation office was not involved.
Well, Ms. Rowland, the term end run, as you said in your opening brief, effectively what you've said just now, that it was meant to describe Mr. Abu-Ghosh's evasion of pretrial services, and that's evidence that the judge was punishing Mr. Abu-Ghosh for exercising his Fifth Amendment rights. The government, in its response, said no, the end run phrase was about Mr. Abu-Ghosh's failure to pre-clear his tendering of checks in excess of the terms of his pretrial release. And your reply doesn't take that up. Why shouldn't we accept the government's reasonable interpretation of those record events?
I appreciate the court's interpretation end run as evasion. That is exactly what it means in our view. And here he talked about the probation officer, pretrial service officer's review. The thing that the probation officer, pretrial services was reviewing were the questions that the court asked them to ask Mr. Abu-Ghosh. The allegation is that he deposited checks that were in violation of the limits that the court had set. Not that he didn't seek permission in advance. He wouldn't have gotten permission because the court had set a $1,000 limit, and obviously checks on his writing as part of the business will sometimes exceed $1,000. So failing to comply with the court's order by doing an end run around pretrial services review really had to refer to the fact of his silence. He brought this up over and over and over again. He was very concerned with it. So, I don't think it's reasonable to interpret that as simply being about the mess. And certainly the court can't find, by a reasonable probability, beyond a reasonable doubt, that is what happened. The law entitled the judge to withhold the reduction for acceptance of responsibility based on a new crime. We simply don't have certainty that that's what he did, that there's at least a reasonable doubt about whether that happened. And for that reason, we ask the court to remand the case to a different judge for resentencing. If you put no further questions about that, I'll move on to the second issue, which is the judge in this case was willing to manipulate the sentencing guidelines for his own benefit by awarding the sentence reduction for acceptance of responsibility to defendants who go to trial, but not when they plead guilty, unless they do so well in advance of the trial date. This policy isn't really about assessing acceptance of responsibility. It's about accomplishing the judge's goal. The judge's thoughts about defendants who plead guilty were discussed at nearly every status hearing. He had personal, strong feelings about the matter. He devised a policy to disincentivize defendants from pleading guilty. So it's natural to infer.
Oh, I mean, the way, I believe the way Judge Leon articulated it was to remove the trial penalty, that he was going to offer acceptance of responsibility points both for someone who pleaded guilty, but also make them available in appropriate circumstances to someone who went to trial, to remove the penalty on going to trial in the event that the defendant would so choose. And I recognize that there were comments that might be thought to create appearance of impropriety when the judge talked about the need for experience on the part of attorneys and judges. But at the end of the day, during the sentencing hearing, none of that was mentioned whatsoever. It was all the evidence of the bad checks in Loudoun County in April 2019 that was the basis, the stated basis, and the only thing that was mentioned as the basis during the sentencing hearing. Why isn't that enough?
Well, if I could first take issue with the court's characterization. The first time this came up at the first status hearing, the judge said that he wanted his brilliant law clerks to devise a way to disincentivize guilty pleas. At the next hearing, he said, my brilliant law clerks have come up with a way to disincentivize guilty pleas, and he couched it in terms of eliminating the trial penalty. But that is not actually what he did. What he did was eliminate the trial penalty and also tell defendants, if you plead guilty, you will not get acceptance of responsibility.
Only if you plead guilty within the 2 weeks before trial, which wasn't at issue here. Right?
Well, this commentary began long before Mr. Abu-Ghosh pled guilty. And what he's done is set up a policy where if you cause the government and the judge to do some trial prep, get ready for trial, no matter what you say after that, accepting the responsibility for what you've done, you don't get the points. But if you cause them to prepare for the trial, to do that work, and then spend 6 weeks in trial with multiple witnesses, you will get acceptance of responsibility points. I think that it's very clear that he's using the guidelines as a check for his own purposes.
The Loudoun County check, the two checks, it's not simply that he didn't clear through pretrial services, but it also was a criminal offense, wasn't it? I mean, he was, one of the checks supposedly was phony, and he's drawing money out from it. So he's committing a criminal offense while he's in between his indictment and the trial date, and yet you think he acceptance of responsibility?
I agree that a court can, of course, deny a defendant a reduction for acceptance of responsibility when they've committed new crimes after they're guilty. But it's not at all clear that that's all that motivated the judge.
Oh yeah, but we can't get into the business of mind reading. On the face of it, objectively looking at it without getting into subjective motivations, the judge was. I mean, I think it'd be remarkable if he gave him a bump for acceptance of responsibility after, what he did in Loudoun County.
It's often the case that judges, maybe always the case, that judges can do something in a way that's legitimate or in a way that's illegitimate. And if there's reasonable doubt based on the record that he was creating a policy that misuses the acceptance of responsibility guideline, then I think there is a reasonable doubt as to whether that was the sole motivation.
Mr. Rowland, you keep mentioning the reasonable doubt standard. Is that the standard by which we assess the propriety of the sentence here?
I believe it is, Your Honor. In the Sonny case, the court said, for most constitutional errors, an appellate court is to reverse if it entertains a reasonable doubt about whether the error affected the outcome below. So, yes, I think that is the appropriate standard. And I think there is a reasonable doubt here about whether the judge's manipulation and antipathy towards guilty pleas affected the outcome. For that reason, and as previously stated, we ask the court to remand this case to a different district court judge.
Thank you. We'll give you some time for rebuttal.
Thank you.
Mr. Leonard.
Thank you, Your Honor. Good morning, and may it please the court, Dan Leonard for the United States. The district court in this case identified one reason and one reason only for refusing to give the defendant credit for acceptance of responsibility. And that was the fact that the defendant had cashed fake checks in Loudoun County after his guilty plea, while he was pending sentencing, conduct that was both criminal and did not comply with the court's order that the defendant notify pretrial services whenever he cashed a check over $1,000.
And just for clarity of the court's order, my assumption was that there was a role for getting clearance from the court or from the officer about, for example, if you inherit, money over $1,000, can you clear it with pretrial services or not?
So I actually haven't seen the specific order that was entered. I don't believe it's in the record, but there was discussion of the fact that, for example, if he had to pay rent, that there would be a way he could pay rent even if it was over $1,000, or similarly, if he had a car payment, that payment is something that could be made. So clearly when this was the discussion that occurred before the order was entered, but the parties envisioned circumstances in which he might have to get pre-clearance. Mm-hmm. Here he didn't even attempt to, which I believe is the court's point.
Did he have to? Yeah, the way you framed it, I hadn't thought about this, but you said it was a prohibition of cashing checks over $1,000 without the approval of the pretrial services group. But he didn't cash these checks. He deposited them. And didn't get cash back. He started writing checks on new accounts.
Perhaps, Your Honor, I'm speaking more vaguely than I should. I don't know what the exact order said, but my understanding is it covered him engaging in transactions involving checks over $1,000.
Yeah, well, it doesn't matter, because the thing that seems to be important here is that both of those checks amounted to criminal fraud.
I agree, Your Honor, and that's...
Right, I think the only question was whether it was plausible that the reference to an end run around pretrial services was a reference to his failure to go to pretrial services before handling such checks, or was it a reference to punishing Mr. Abu-Ghosh for exercising his Fifth Amendment rights? So it does seem that it's important to the government's theory whether there was some interaction with pretrial services other than the mandated interview that might be the subject of the end run comment. Is that right?
Your Honor, yes. There were two end run comments at the sentencing hearing. The defendant does not dispute the clarity of the first, which the district court made when refusing to grant acceptance of responsibility. That's 631 to 32 of the appendix, that's when the district court said, I'm not giving you acceptance of responsibility. He talked about, the court said, I find by a preponderance of the evidence that the checks were fictitious and that there was every reason for the defendant to believe they were fictitious. The court then went on to say, so he did an end run on contacting the probation office on both occasions and on the occasion of opening up a new bank account, which was also in violation of this court's order. And so that end run comment was plainly about the requirement that he get pretrial services approval before engaging in transactions with checks over $1,000. Later in the hearing, when the defendant asked to be able to self-surrender and the court denied that request, the court again used this end run around probation language, but again tied it to his failure to get pretrial's approval. The court said, by doing an end run on the probation office's review, by opening bank accounts you weren't supposed to without checking them with them first by negotiating checks over $1,000. And so again, the end run language was expressly tied to this requirement that he get pretrial's approval before opening businesses or cashing checks. And so there is no doubt, reasonable or otherwise, that the basis for the district court's denial of acceptance of responsibility was new criminal conduct.
And is the standard reasonable doubt?
You know, our brief didn't ultimately find cases setting forth the standard of when you look behind the district court's stated reasons for acting and guess at his ulterior motivations. But Ms. Rowland correctly said that Sinai has a quote from another case suggesting that when the this court entertains a reasonable doubt about whether there was constitutional error in the sentencing, and new sentencing is appropriate.
And if the comments about trial and the, getting rid of the trial penalty or creating opportunity for lawyers and judges to get trial experience, all of those comments were made at sentencing, and if there were not the intervening handling of the bad check, is there any question? Is the government's position that would have not been error, or?
So I certainly for the Fifth Amendment, we have not argued that the district court may deny acceptance of responsibility because the defendant invoked his Fifth Amendment rights, although that is an open question. The Supreme Court did not address it in Mitchell. This court did not address it in Sinai, and we did not address it in our brief. So on that point, we haven't taken a position, and we don't think this court needs to. If instead the court was saying, because you chose to plead guilty instead of exercising your constitutional right to go to trial, I am not awarding acceptance of responsibility. I guess I don't know the answer to that. I don't know if that's permissible or arguably permissible, but it's certainly not what occurred here.
It doesn't appear to be what occurred here. As the judge announced his own policy, he said, if you plead guilty, you're eligible. If you go to trial, I'm still going to allow you to be eligible. The only exception would be if you pled guilty late, within 2 weeks, which isn't what happened here. But I think there's a distinct concern that Ms. Rowland has raised, which is just the insistence, repeatedly, I think it was 7 times, she says in her brief, the judge clearly wanted the case to go to trial. And he makes that very clear and very explicit. And I guess the question is, even if we find no error, what to make of that? Is that a problem? Is that something that a district judge should avoid doing? Or do you see that as really neither here nor there?
Well, I think I have 2 answers to that, Your Honor. The first is that this district judge's policy of allowing defendants to get acceptance of responsibility credit even when they go to trial is a pro-defendant policy. It benefits defendants in the vast majority of cases. And so it's hard to see how this case presents an issue to criticize that policy. As far as the district court pushing this case to trial, ultimately I accepted the defendant's guilty plea. But also, I think the record reflects that the district court was not, in fact, pushing this case to trial. It was indicted in September of 2015 and lingered for years. The district court was routinely giving the defense 60-day continuances to refute discovery, to consider plea agreements. He was, regularly allowing lengthy delays in the case to review discovery. And so there was he repeatedly said it would be a good thing to have more trials, and I have a policy that allows defendants to get acceptance of responsibility. And certainly he was frustrated after he accepted the guilty plea and realized that this defendant had gotten what, in his words, was a sweet deal. But certainly given the something like 3-year delay between indictment and the guilty plea and another 1.5 years before sentencing, there was no insistence on going to trial. This is not the UVA rocket docket by any means.
I also had a little bit of a confusion about the government's position on the criminal conduct that's relevant to acceptance of responsibility, because as I understand it, you argued in your brief that any post-indictment criminal conduct is relevant to acceptance of responsibility, but the government, consistent with the defendant, took the position that the 2017 Fairfax charges didn't stand in the way of getting credit for acceptance of responsibility, and then the Loudoun County charge did. But if post-indictment is the measuring point, the two events seem equally relevant.
I think they're relevant for different purposes. I think the government's view is that any post-indictment criminal conduct is relevant for acceptance of responsibility as the guidelines have been written. But in this particular case, because the government knew about this post-indictment conduct and nonetheless entered a plea agreement with that knowledge, in which the government agreed to give the defendant acceptance of responsibility, that in this case, by entering that contract, by entering that plea agreement, it was saying that that particular conduct was not relevant in this specific case because the government knew about it and nonetheless entered this agreement. However, the subsequent Loudoun County conduct, which postdated the plea agreement, was not conduct the government knew about at the time, and the government ultimately agreed with pretrial and the court that continued criminal conduct and continued fraud what meant that the defendant should not be granted acceptance of responsibility credit. If there are no further questions, we'd ask that the judgment of the district court be affirmed.
Thank you. Ms. Rowland, I think you had only a few seconds left, but we'll give you 2 minutes for rebuttal.
Thank you. Regarding the delay between indictment and resolution by either a guilty plea or trial, it's just unrelated to whether the court was pushing Mr. Abu-Ghosh in one direction or the other. He certainly wasn't pushing to make it happen quickly, but what he was pushing for is what's relevant. We do not criticize a policy that would eliminate the so-called trial penalties. What we point out here is that that's not all that the district court did. The district court created a policy in which defendants are in the very strange position of not getting acceptance of responsibility points if they don't accept responsibility, or the judge puts some work into the case, but they can get it if the judge puts a lot of work into it. Finally,
well, you're criticizing the 2-week limitation, but that's not relevant to this case. That didn't bear on this case. The 2-week window is the basis of the argument you just made, but that's just not relevant here.
it is not relevant to Mr. Abu-Ghosh directly. I think the reason we bring it up is it is evidence of the judge's antipathy toward guilty pleas, and the fact that he wasn't simply just doing defendants a favor by eliminating the trial.
The delays in this case were at the defendant's request, or you haven't argued that the delays are the judge's prodding the defendant to go to trial or resistance to accepting a guilty plea?
Absolutely not. No. I think the delay is completely irrelevant to any legal issue here.
Okay.
And finally, I just want to say, the government has urged you to look at context, and I think you should, and to listen to the judge's words. If a judge said racist things at a black defendant's hearings leading up to final sentencing, but then stated a legitimate factor for its sentence at the sentencing hearing, we would be right to question whether the previously stated views affected the sentence, especially where the court doesn't disavow it. Of course, that's not the case here, but I think it's a useful analogy.
All right.
Ms. Rowland,
Oh, yes.
did you ever object when the district court said all these things that you think the district court shouldn't have said?
There was one objection. Look in the record. There was one objection where the defense attorney suggested an Alfred plea, and I'm sorry, I'm not able to find it right in our plea. The judge, she suggested an Alfred plea, and suggested that it would be in the public's interest because it would save the government and the court a trial. And the judge said, "We don't want you to save us a trial. We don't want that." And she said, "Well, but it is in the public's interest to accept a plea in this case."
All right, thank you. Any other questions?
No.
All right, thank you. Counsel will take the case under advisement.
Case number 20-1291, Warbird Adventures, Inc. and Thom Petitioners versus Federal Aviation Administration. Mr. Winton for the petitioners, Mr. Torture for the respondents.
Good morning.
Good morning.
Mr. Winton, you may proceed when you're ready.
Thank you. Good morning, Your Honor. Good morning. May it please the court, counsel. My name is Gregory Winton, and I represent Warbird Adventures and Thom Richard, the petitioners in this matter. It's a very simple case, which is interesting because it involves 75 years of well-documented aviation history. And the FAA's emergency cease and desist order, which is basically issued against my client to stop them from immediately providing flight training in a limited category aircraft, which is a surplus military World War II aircraft, or flight training for hire without an exemption to the regulation. And so we have to look at the regulation history to determine whether the FAA ever intended to limit the provision of flight training for hire in these aircraft. Now, the FAA's order must fail for two reasons. One, specifically, it's an abuse of discretion. It's not supported by any law, and it's arbitrary and capricious. More significantly, it fails the substantial evidence test. Remember, the FAA's emergency authority and the emergency order in this case was based upon the finding by the administrator that an emergency exists related to safety and air commerce. But what's the basis for the order? It's the failure to comply with the agency's interpretation. It was an interpretation, an anomalous interpretation, issued by letter in 2014, which we call the Morris interpretation because it was written by Mr. Gregory Morris. and that appears as JA-12 in the joint appendix. And what that said was the only way to provide flight training for hire in a limited category aircraft is pursuant to an exemption. Well, let's look at the history, right? And that's what I did. And many things were learned during that process, but most importantly, I found that either the FAA, in issuing the Morris interpretation and the emergency order, either didn't do the history research, which is concerning, or they did their history research and issued the order anyway, which is contrary to law. But what did I find out? 1946, the end of World War II, we had surplus military aircraft. Nobody knew that there was going to be a demand for these airplanes. So the CAB, Civil Aeronautics Board, predecessor to the FAA, actually enacted and promulgated a regulation, Part 9, that said, okay, we'll allow civilians to use these surplus military aircraft, including those that were built specifically designed by the military for training purposes, high-performance military training. That's great. And so they issued the regulation, which had a limitation. I'll read it. This part is for the purpose of making available to the public certain military surplus aircraft, which were originally designed for the military services of the United States for combat and other specialized purposes, i.e. flight training, and which experienced military service has shown to be safe for operation. However, there is a caveat. The CAB made these aircraft available to the public so long as the flights are neither for carrying passengers or cargo for hire. Okay? Didn't say anything about limiting flight training at that point. Now keep in mind, in 1945, a year before the regulation was just enacted that I read, the FAA and CAB actually defined the term passenger, which was an occupant of the aircraft other than a crew member. So there's a reason why the CAB said you can't carry a passenger. It didn't say you can't carry a crew member. And in fact, when the CAB enacted Part 9, one of the certification requirements, which still holds true today, was a placard prominently displayed in the passenger compartment of the aircraft. And by the way, this placard is still in Thom Richard's aircraft, 75, almost 80 years later. This is a military-type aircraft, and under the civil air regulations, shall not be used for the carriage of passengers or cargo for compensation or hire. Every year that aircraft is inspected, and that placard has to remain in the aircraft, and it remains there today. So, 1949, the CAB continued to enact regulations, and they said, in that case, student instruction shall not be considered the carriage of persons for compensation or hire. So there's an exclusion for crew members, and there's an exclusion for flight instruction. There's no question about that. The FAA's inquiry into this issue should have stopped right there and then, but it didn't. So what happened in 1962? The FAA amended Part 1 definitions, and they removed the term passenger. So now it's no longer a passenger can't be carried for hire, but they replaced it with the word person. The FAA suggests...
May I interrupt you for a second? I just want to be certain about this. You say the amendment to this regulation that changed the word passenger to persons happened in 1962?
Correct.
And so that presents a problem for you, doesn't it?
Not at all, because...
Well, actually, it's not a problem for you. It's a problem for the FAA. And the problem is this, that if you go to the Federal Register that you're talking about in that year, the preamble says that they were intending no substantive changes.
Correct. In fact, the language...
So the point is that if in fact that's when the amendment occurred, the amendment from passenger to person didn't change anything. But the FAA relies on the idea that it's persons rather than passengers.
Right. And specifically, the language was in the Federal Register, this did not change any of the pre-existing regulatory requirements. Right. So anyway, look, then we have in 1998, the first exemption was granted, right, which meant specifically that the FAA CAB was aware from 1946 to 1998, 52 years, that the public was using this type of aircraft, this military trainer, to provide flight training for hire without an exemption. Makes no sense. Again, the inquiry should have stopped there. So the FAA either knew that there was no law to support this Morris interpretation, and they issued it anyway, And then in 2020, the Assistant Chief Counsel issued an emergency cease and desist order based on the anomalous interpretation, or they just didn't do the research at all.
Also, based on information communicated to your client that he was violating the regulations. I mean, even if he has an argument about that, going out and persisting in flying and advertising flight training in the face of that is scofflaw behavior, is it not?
Oh, not at all. Keep in mind, we have due process rights. And remember, the FAA, within a 2 or 3 week period, issued an order of suspension, issued a civil penalty against Warbird, and they issued this emergency cease and desist, all of which are presently under review by either the National Transportation Safety Board or this honorable court. So my client is not guilty until proven innocent.
And has your client, since the briefing, requested an exemption and proceeded through that process, or no?
We have not, because the exemption is not applicable in this case. Specifically, if you look at the original exemption granted to Stallion, which is the gold standard that the FAA presented to us, and by the way, the FAA didn't present the original Stallion exemption, I did. It's exemption number 6811 in the reply addendum 9, and it says specifically, the FAA assured Stallion 51 that because Stallion 51's aircraft have dual cockpits and fully functioning dual controls, and because the training would be considered a crew member and not a passenger, Section 91.3.1.315 would not apply. That's our position. That's the FAA's position. We didn't make this up. So we're adopting the FAA's position, which is the correct position all along. I see that I've used my time. I'd like to reserve the rest.
I have a couple questions for you. First of all, what is the status of the regular administrative proceeding, not the emergency, obvious?
I'm glad that you asked, Judge. I asked that last week, and so the Chief Judge from the National Transportation Safety Board has been sitting on a motion to stay that was filed by the FAA 3 months ago. And the basis for the motion to stay by the administrator is this case is pending before the D.C. Circuit Court of Appeals. So they're waiting for you to put a hammer on the nail.
We should be waiting for them, because if they rule, then this case is moot.
Well, not necessarily, because if they rule against my client, right, I can appeal it, and then it would wind up right back in the same chambers that we are today.
With a different issue.
Well, I'm sure that's a good point, right? We're asking the court here to deny, vacate, and set aside the FAA order, not only because it fails for lack of evidence concerning the emergency, but also that it is not supported by law, right? The emergency cease and desist order. Look, if there's any question about the FAA's emergency authority, we all just saw it last Tuesday when the FAA issued an emergency order against the 777, Boeing 777, but they didn't ground all airliners. They didn't ground all 777 aircraft. They grounded only those with the Pratt & Whitney engine that had a problem that was scientifically designed that caused a problem, and the FAA pinpointed that was the emergency.
Okay, my second question is is there anything in the record to indicate that your client, during or after the negotiations with the FAA, in fact, continued to fly training pilots? The only thing I see is that that your client advertised that it could do it, but did it, in fact, fly or train do in-flight training?
Right. Yes. So keep in mind the original.
What's the answer?
The answer. So the answer is no. When I got the letter from the FAA, I responded and said, "Look, the flight training itself, we don't believe is a violation of the regulation, but they are threatening to shut you down with an emergency cease and desist order and an emergency revocation of his pilot certificate." So that's why he shut down the entire air show season.
So there was no in-flight training after that period when you received the letter, but there was advertising. It was just advertising, right?
Yeah, I had him take down yes, correct. He took down the website not long after that.
What's the date on the letter?
The letter to me was February, well, there were a series of letters between myself and the FAA. Pardon me. So Naomi Tsuda, July 20 of 2020 is when I wrote back to her. July 22, 2020, I wrote to her, and July.
There's an April 2019 notification from the FAA about its position that Warbird was violating 91.315.
I'm looking at the joint appendix. For some reason, I have all of my response letters to her in sequence to Naomi Tsu, the Assistant Chief Counsel for Enforcement, but I don't have her initial letter. The only initial, I'm sorry, it was July 17, 2020, that she wrote to
Mr. Witten, on JA6, which is on that page, paragraph 11, it says, on or about April 3rd, 2019, FAA inspectors advised Thom Richard that operating plane carrying persons for compensation constituted a violation of 91.315. Now that is to your credit, not a formal letter, I don't think. I think the formal letter that you're talking about comes in 2020. But there was that notification by the FAA. And then if you skip 2 paragraphs down to paragraph 13, on January 31st, 2020, Warbird operated the plane.
Right. Was there a question relating to those?
Well, question. Go ahead, Judge Walker.
Please, Judge Fillard. All you, Judge Fillard.
So the point was just that FAA inspectors advised Richard as of April 2019 that carrying persons for compensation was a violation. And then there's a further allegation that after that communication, that Warbird not only continued to advertise, but flew. And this is just relevant to Judge Randolph's effort to get clarification on whether the only continuing conduct that was the basis for an emergency order was advertising, or whether it also included flying.
No, so
and one way of reading this, it seems the clearest way of reading this, is that after Warbird was on notice of the FAA's position, it did continue to fly with passengers, with people on board.
Well, an inspector's notice of an apparent violation, and that's all an inspector can do, versus a letter from the Assistant Chief Counsel for Enforcement at the FAA, which was JA-16 dated July 17, 2020, has a much different effect, right? An FAA inspector cannot come onto a field, an airfield, and stop a pilot from operating for an alleged violation, right? But they can put a stop order on an aircraft if they find it to be blatantly unairworthy, which is not the case here. So we are correct. We continue to fly after the inspector advised my client that he may be in violation, but after Naomi Tsuda from the FAA Assistant Chief Counsel's Office issued the July 17, 2020 letter, we did not continue offering flight training for hire in a limited category aircraft.
And was that position, that voluntary, temporary acquiescence with the FAA's position, ever communicated to the FAA?
Yes. I mean,
in other words, if you're the FAA and you're thinking, I understand that Mr. Witten's client has a different position on the law here. If the FAA's responsibility is to protect the public, what basis would the FAA have to believe that Warbird would not be flying during that period when Warbird was challenging the FAA's position?
Well, I was in constant communication with the FAA throughout the process after these letters and even after the emergency cease and desist order was issued. And I let them know that we're not flying, right? So, but it begs the question as whether or not the operation of my client's aircraft for hire in the instructional setting is an emergency related to air safety. It's not.
Well, there is a basis in the record to think that unauthorized flight of this kind of plane does present a safety risk.
Oh no, that's merely say-so of the agency. There's absolutely no evidence to support that whatsoever. I mean, this aircraft was designed for flight training to military specifications. When something is built to a military specifications, that's like the gold seal of engineering. And the fact that this aircraft's been around, it's going to be 80 years now, is still flying.
I thought the FAA said that actually during World War II, We were understandably in something of a rush to build as many planes as we could, and so we actually didn't require the same kind of safety standards that we later required and that we now require.
No, there's no evidence of that whatsoever. Absolutely not.
JA 17 is what I think we're thinking about, where the FAA says, states its position. This planned operation could pose a significant risk to aviation safety. As you're aware, limited category aircraft were originally produced for the military. These military surplus were produced in the 40s, and this one was manufactured in 42. They're generally older. They're not inspected and approved for airworthiness according to the same standards as civilian aircraft. There's serious public safety concerns because of increased public interest in these flights. And their conclusion is that these types of operations pose impermissible risks to air safety. And in your view, that's not enough to support a safety-based action on FAA's part?
But it's not true. Correct. It's not true. They are inspected in accordance with regulations. In fact, the FAA, in their brief, admits there are experimental certificated aircraft. The same airplane, the P-40 Warhawk, can be experimental certificate on the airworthiness or limited category. The FAA admits that the experimental is not as safe as the limited, but yet the FAA allows flight training for hire in an experimental version of the
where people have obtained the permission from the FAA. That's the issue. And you're saying, well, no, we have a right to do that, whether the FAA wants to, whether we've gone through and gotten the authorization or not.
No authorization.
Are you raising a discriminatory enforcement claim here?
If that's what it is, yes, absolutely. Because remember, I just read to you the grant of exemption, the one and only first grant of exemption for the same type of aircraft. The FAA assured Stallion 51 that because the trainee would be considered a crew member and not a passenger, 91.315 would not apply. Again, that's the reply addendum, page 10. They can't make this up. This is the FAA's document.
I have one more question that I was going to ask you. It just slipped my mind. Who owns this aircraft?
It's owned by an LLC. That's I guess part owned by Thom Richard himself. Which brings up a good question, because if Thom Richard...
I'm sorry, you cut out.
Oh, sorry.
Yeah, if you could repeat that.
It's owned by a separate entity, a separate LLC, P-40 LLC, I think is the name of it.
And your client, Mr. Richard, is that his name, is the president of that company?
I believe so, but I'm not absolutely sure. He is part owner, if not complete owner of that entity.
The company. So if he goes up without a passenger, without no in-flight, he just operates the plane. I take it that, and the corporation owns it, I take it that the corporation compensates him. Isn't that?
Oh, the other way around, actually. He has to compensate the corporation because the corporation is a shell company that owns an airplane, right? Oh. And so the only way the plane can fly is if Mr. Richard gives money to the corporation, which then that corporation is operated a limited category aircraft carrying Mr. Richard as a passenger or person, I should say, according to the FAA. That doesn't work.
And the limited liability.
That's where I was going.
Right.
Because it means that nobody, a plane operated or owned by a separate corporate entity, nobody can fly it. One of these, this type of aircraft.
Without an exemption, correct.
Right. Okay.
The FAA actually calls that a corporate flight department when you set up a company just to own an aircraft, and it's got to be legally done in a commercial setting, but this is flight training, so it's different.
Okay.
I have nothing more. I'd like to reserve some time for rebuttal. Thank you.
Thank you. I'll give you 2 minutes for rebuttal. Mr. Starcher.
Good morning, Your Honors, and may it please the Court, Jack Starcher on behalf of the Federal Aviation Administration. As was discussed during the other side's argument, the FAA during the course of more than a year repeatedly communicated to petitioners that their conduct ran afoul of the plain text of Section 91.315, and despite that ongoing back and forth, during which time, as sort of documented in the administrative record, during which time petitioners raised many of the same points that they now raised before this Court, FAA responded by pointing petitioners not only to the text of 91.315 as it currently exists, but also to the text of various neighboring regulations, which use materially similar language referring to carrying of persons or property for compensation or hire in a way that is totally inconsistent with petitioners' proposed reading of Section 91.315. And petitioners really provide no response to what, in petitioners' view, these other regulations mean if flight training is not included in the concept of carrying persons or property for compensation or hire. If that phrase.
Just to go back, he claims that this change from passenger to person was 1962, and I had the impression in my own review that there was a December 1950 Federal Register notice.
That's correct.
Send down for us. But he's citing to something that he says that contemporaneous with that they did not mean to exclude training at all.
Right. So in 1946, you have the enactment of the predecessor that would eventually become what is now Section 91.315, and that is the time at which that predecessor used the term passengers. But just a few years later, as you say, I have the same Federal Registry notice from December 15th, 1950. Which is 15 Fed Reg 8895. And it was at that time, so just a few years after this 1946 passengers use, that the regulation changed. To be sure, in that regulation there is a sort of preamble that says, in most significant respects, this part does not attempt to change current procedures or practices. But then the regulation goes on to in fact make a change to this regulation. And so so the one thing we do know about this change is that it is a change from the word passengers to the word persons, and just sort of on its face, the word persons is a broader, more capacious term than the term passengers, just as a matter of sort of a natural English language use. And so from 1950 until today, the various iterations of this regulation, culminating in what is now 14 CFR 91.315, have continually used the phrase persons or property for compensation or hire, which is materially different from regulations, other regulations that FAA still has on the books that continue to refer to passengers. Those regulations that use the word passengers are almost all have to do with certification requirements for pilots, whereas here we're talking about certification requirements for an aircraft itself, and so it makes sense that those terms are different. And again, I do just want to underscore, as pointed out in our briefing, and again, petitioners.
I don't really understand the certification for pilots versus certification for the aircraft. Can you explain that?
Yes. So the FAA regulates both pilots and planes, and regulates those things separately. So any aircraft that is operating in the United States today must be certified in a specific category by the FAA, saying this is a plane that is airworthy to perform the following set of functions and is safe to perform the following set of functions. And there are different categories. There's the standard category, which has various subcategories, and that's where most sort of commercial airplanes exist. And then there's the land of special category certificates, which is where we are now. That whole scheme is sort of separate from another scheme that FAA has to make sure that the people flying any aircraft.
Well, let me stop it on the certification. This plane has not been grounded, has it?
Not to my, I think the cease and desist order is limited to flights in violation of this regulation, which means that this flight could still be operated in conformance with this regulation. In other words, for any purpose, for private or recreational uses, as long as it's not being used to carry persons or property for compensation or hire.
Okay.
So yes, that's correct. But again, just to underscore this, as explained in the briefing, multiple other regulations that are very close in proximity to 91-315 and that place very similar limitations on other kinds of special category aircraft, use identical or materially similar phrasing and refer to this prohibition against carrying of persons or property for compensation or hire, and to then move on to in various ways say, despite or carving out from that prohibition, flight training. And if the carriage of persons or property for compensation or hire doesn't include flight training, as petitioners suggest, then all of these other regulations that expressly provide ways for people to provide flight training, notwithstanding that prohibition, just simply don't make any sense. And again, I don't think there's any response to that.
Mr. Starcher, let me ask about something that I think Judge Randolph was asking about when Mr. Winton was speaking. The official letter from the FAA told the petitioner on July 17th, 2020, it's illegal for you to do what you're doing. Yes, an inspector had mentioned a year earlier, but anyone who's dealt with, for example, a building code inspector while doing a home renovation, knows that sometimes a random inspector doesn't always speak officially and with the full authority of an agency. So the agency itself did not say what you're doing is illegal in an official authoritative way until July 17th, 2020. And then I see nothing in the record, and certainly nothing in the emergency order, that provides any evidence, substantial evidence, that the petitioner was in violation of the law after he received that letter on July 17th, 2020. So tell me why we shouldn't say this. There's no substantial evidence that the petitioner was in violation of the law when the emergency order was issued.
So two responses. First, sort of a factual. So if you look at JA 13, there were discussions. That's the first, I think, formal letter you have from the FAA. This is from February 14th, 2020. That's a letter memorializing a meeting that was had with petitioners in the FAA. So there was even before July, there was an official sort of.
But Mr. Starcher, that February 14th letter is after January 31st. And January 31st is the last time that the petitioner flew the airplane, at least the last time we know based on anything in this record.
Right. So if you look at the July 22nd letter, this is JA 24 to 25, and particularly I'm looking at JA 25 here. During that back and forth that happened in July, which was spurred by FAA becoming aware of Facebook advertisements that were posted to Facebook soliciting people, inviting people to come and fly in this aircraft at upcoming flight exhibition shows. There's this paragraph on page J25 saying, again commemorating, memorializing FAA's view on this and saying, accordingly, I ask that you respond to this letter stating whether your clients intend to charge persons to carry them in flights in the P-40 as the website and advertisements indicate. And if your response does not provide sufficient assurances that your clients do not intend to do this, then at that point, the cease and desist order would be issued. And so FAA was making it very clear its position that this was unlawful. It gave petitioners the chance to say, I think, exactly what we had in mind, which is, no, we're not doing this. We haven't been doing this. We don't intend to do this. And if you look at their response continued to essentially rely on this same theory that they presented this court, which is presumably that no, we don't intend to do this because we're intending only to take people up in the air for flight training.
Is that how substantial evidence works, Mr. Starcher, that an agency can say to a person, prove to us that you're not violating the law, and if you don't prove it to us, then we conclude you are violating the law?
So to be clear, I guess first up, the cease and desist order is only preventing petitioners from flying this aircraft in violation of the regulation. So to the extent that the state of the world was that petitioners never intended to do that and never intended to operate this plane in violation of the regulation, then it's a cease and desist order that does nothing. And
that goes to Judge Randolph's mootness inquiry, right? It's possible that this emergency order dispute would be moot, and then the merits would be fully litigated at the agency level before coming to us.
I don't believe that's correct. So the issues presented in the two proceedings that are still going on in the sort of agency level are specific enforcement actions against both petitioners separately, Richards and Warbird. And I believe my understanding of those is those are both based on showing proven past violations. And so those really are more, I think those are based on past proven. I'm not as intimately familiar with those two proceedings, but the issue presented in this petition is whether or not this cease and desist order, which continues to have effect, is lawful. And so I think regardless of what happens in those administrative proceedings, this court still has a live question before it in any event about whether or not this cease and desist order is lawful.
Is there a proceeding pending for obtaining certification, or there isn't because Warbird doesn't think it needs that?
There's no pending exemption petition. So Warbird has never, petitioners have never sought the kind of exemption that Stallion 51 Corporation has and that numerous other entities have received, which allow those entities to conduct flight training or living history or other kinds of operations in these limited category aircraft for compensation.
And I had the impression that the FAA was relying on the continued advertising as circumstantial evidence that there were training flights going on. Is that wrong?
No, that's correct. I mean, there was a system, I think on Warbird's website where you could sort of click through and through an online portal sign up for flight training. But I think more concretely, Warbird, this plane was scheduled to be at specific flight exhibition shows, sort of at specific dates, I think coming up shortly, around the time the emergency cease and desist order was issued.
But wait a minute, that would have been perfectly legal if what this order prohibits is carrying somebody else in the aircraft. I mean, it could go to a flight show and the president of the company can pilot the plane, and there's nothing indicating that is in any violation. Isn't that right?
That's correct. Sorry, to complete that, I sort of led with this, and at those flight shows, there were advertisements. So I think the Facebook advertisement that kicked this all off was, sign up for a flight in this plane at the upcoming.
Right. I mean, the only evidence that I've found is of advertisements, not of flights after July.
Right, and to be clear,
in-flight training. I'm sorry. Yeah.
Right.
Yeah.
Sorry, and to be clear, that is, the reason why these sorts of cease and desist orders are so uncommon is because it is sort of an uncommon circumstance that FAA found itself in here, where it saw advertisements where someone was saying, I am going to go out and conduct flights, or I'm offering to the public flights that are in violation of a regulation. That's the way in which this case is really like the Ickes case from the Third Circuit. It just doesn't happen that often that FAA learns in concrete or sort of has good reason to believe that a violation is going to take place before it happens. And again, it's uncommon for people to publish to make advertisements about conduct that FAA has already told them.
Is there an inconsistency within with the agency, on the one hand, allowing this plane to go up with Mr. Richards piloting it and go to shows and so on and so forth, but not to go up with somebody that's getting trained to be a pilot?
No, Your Honor. This distinction, between compensation or hire, paid flights, commercial flights.
Oh no, I understand that. I'm not questioning about the regulations, okay. But I'm talking about the emergency order. If it's supposedly based on safety, then how do you explain the FAA's not doing anything about the plane when it's at shows with lots of people watching and so on and so forth?
Oh, it's the potential danger, just like people on the ground. So there are lots of regulations that FAA has in place that have to do, and this is at issue in ICCES, was regulations that are concerned with sort of like people watching air shows or present at air shows. I'm not super familiar with those, but this regulation is really focused on the safety of being in the aircraft and being on board the aircraft and the aircraft's, the danger it poses to people on board the aircraft, I guess.
This is a total aside that had nothing, my question has got nothing to do with this case, but I'm curious. This regulation doesn't apply in Alaska, does it?
I don't know.
I don't think it does. Yeah.
It might not.
Yeah.
So, but I'm not aware of that, so I can't say yes or no. But it applies in Florida, which is where Petitioners are based. So, and if there are no further questions, we ask that the petition for review be denied.
Just to double check, ICCES is really the case you rely on for the validity of the exercise of FAA's emergency authorities. Is there anything else you think we should look at?
I mean, I think if you just look at the text of the statute itself, speaks about, if any time in the opinion of the administrator of the flight of the Federal Aviation Administration, that phrasing, in the opinion of, is the sort of phrasing that in other contexts courts, I think, have consistently found expresses an intent by Congress to give pretty broad authority to ensure safety in aviation. But I think the ICCES case is the case. Again, these emergency cease and desist orders are not that common, so perhaps it's not surprising that there aren't a lot of cases dealing with these things. But that is the case that I think is the most analogous to what we have here.
And the administrative proceedings, that's not something that your office has any control over, their decision to wait versus proceed.
That's correct. So we haven't had any involvement of those, and my understanding is that they are essentially in a holding pattern, waiting on this case. I think, but again, I don't have any insight into that beyond what's in sort of publicly available documents.
Thank you.
Thank you.
Mr. Whitten, I think you used up your time, but we'll give you 2 minutes for rebuttal.
Thank you very much. So just get back to Judge Randolph's question about the aircraft not being grounded. Obviously it's still flying. In fact, the FAA at respondent's brief, page 5, says any person who wants to fly a limited category aircraft, and I quote, is afforded that privilege absent financial consideration. That means the FAA is allowing my client to provide flight training in his aircraft as long as no compensation is exchanged. So if somebody buys him a hamburger after the flight training, that's compensation all of a sudden in the eyes of the FAA. That same flight training scenario becomes unsafe. Makes absolutely no sense, isn't supported by evidence in the record. First of all, we have to understand something. Flight training never has been and never can be considered carrying flight training for hire, considered carrying a person for compensation. It would turn the entire industry upside down. I'll give you an example. I have access to an airplane in the airport. I've been a flight instructor for 35 years. If Judge Randolph says to me, let's go to Ocean City to have a hamburger, I can't fly him there if I wasn't going anyway. I could give him a lesson. We could stop in Ocean City, have a hamburger. I could give him a lesson coming back, charge him for flight training, sign his logbook, and we have just done what we wanted to set out to do. But I can't, if he is a person being carried for compensation, I would need to have an air carrier certificate issued by the FAA, which was the Flight Now case, which is another one of my cases before this court. You cannot operate an aircraft for compensation carrying a person without an air carrier certificate. That would make every flight instructor in the United States have to get a flight instructor, air carrier certificate. And to answer your question, Judge Randolph, about Alaska, you quoted a great statement by Holdsworth, English law, that those regulated by an administrative agency are entitled to know the rules by which the game will be played, right? My client didn't know that there was a rule out there that said he couldn't provide flight training for compensation because it's nowhere in the history of the FAA. We ask that you vacate and set aside the emergency order, but not only because it's not supported by substantial evidence concerning the safety concern, but because 91.315 of the regulation is contrary to law. Otherwise, you're going to see me here again making the same arguments in a year and a half from now. And that's just a waste of judicial resources. Thank you for your time. I appreciate it.
Thank you, counsel. The case is submitted.
Case number 20-7040, Broidy Capital Management LLC and Elliott Broidy versus Nicolas D. Muzin et al. Appellants. Mr. Obermeyer for the appellants, Mr. Coffin for the appellate.
Good morning, counsel. Mr. Obermeyer, you may proceed when you're ready.
Good morning, Your Honor. Thank you, and may it please the court. My name is Steve Obermeyer, and I represent appellants Nicolas, Muzin, and Stonington Strategies, LLC. I'm also arguing today on behalf of appellants Joseph Allahan and Gregory Howard. This case challenges the legality of diplomatic decisions made by the foreign sovereign state of Qatar. The Ninth Circuit has now held that Qatar is entitled to immunity for the exact same wrongful conduct as alleged in this case.
But Mr. Obermeyer, Qatar's not a party here, and there's no evidence that the defendants in this case were employed by Qatar or that Qatar chose them as its agents here. In fact, I'm not even sure why you have a right to appeal given those facts. Can you at first address our appellate jurisdiction?
Yes, I'd be happy to, Your Honor. First of all, what's been alleged is that appellants are agents of Qatar acting at the direction of Qatar. The whole theory of Mr. Broidy's case is that Qatar decided to do, not to target Mr. Broidy, but to do a hacking and dissemination scheme, which he directed appellants to do. Those are the allegations in the complaint. So the absence of evidence at this point, I don't think is an issue, because that's what Mr. Broidy says happened. He pled himself to that.
We, in subject matter jurisdiction, we don't always just go on the pleadings, and the record suggests a lack of even a formal agency relationship between defendants and Qatar. The contract that is in the record said that the embassy doesn't acknowledge these people as their agents.
Well, the contract in the record, Your Honor, says that appellants were hired to do various lobbying and diplomatic work on behalf of Qatar, and then Mr. Broidy goes farther and alleges that appellants were directed to conspire to hack and then distribute materials from the hack in order to advance its political agenda against Mr. Broidy.
I'm reading from Mr. Muzin's opening brief on the motion to dismiss, which the other briefs incorporated by reference on page 23, note 11. He says, the Qatari embassy states that it does not establish an agency relationship between Qatar and Stonington, and it cites to an exhibit in the California litigation.
That's correct, and that's what the contract says. But what's alleged is that what's alleged in the case is that the relationship started off doing lobbying and turned into, I don't know the exact word, something worse when Qatar directed appellants to participate in a hacking conspiracy.
Well, you're going to help us out. The complaint alleges you're going to help us out in all these various ways, but it also says, and you're not our agent, by the way.
Well, the contract said that, but the complaint alleges that they are Qatari agents, and I would point you to actually Mr. Broidy's own words in his opposition to the interlocutory appeal motion on page 8. He says that appellants were plainly agents for Qatar, and he also says that he alleges that defendants acted at Qatar's direction. He also says in his opposition brief here that Qatar and appellants sought to isolate and marginalize Broidy's influence through a tried and true Qatari tactic, an illegal hacking and media distribution. That's Broidy's own characterization of his complaint.
I understand that you're relying on the characterizations in the complaint, but there's something peculiar about basing our jurisdiction on those allegations when we have reason to believe, when we don't have any reason to believe that Qatar has actually sought to assert its immunity for your client.
Well, I guess a few things, Your Honor. On the jurisdictional point, this court has been clear that foreign sovereign immunity is a collateral order doctrine issue. Conduct-based immunity that is what we're dealing with here is immunity of the foreign sovereign.
So what case do you have where there's interlocutory appellate jurisdiction and there's no foreign state, or in the case of Samantar, putative voice on behalf of a putative sovereign involved in any way?
I'm not sure about the absence of the sovereign in any way, but the cases I'm thinking of are Farhang, I believe it's the Malani or Matani decision in the 11th Circuit. Farhang is Mamani, right? Farhang is in the 9th Circuit, and then also Samantar.
The cases you cited, I thought, were PNID versus Nigeria and Kilburn versus Libya from this court. And those cases both involve sovereigns, claims against sovereigns.
Yes, Your Honor. Specifically, this court, we cite Kilburn, we cite PNID, but those cases, like I said, say that foreign sovereign immunity satisfies the standard for collateral order doctrine, and in conduct-based foreign sovereign immunity is the immunity of the foreign sovereign. So it's our position that that's covered, and in the cases I was referring you to from other circuits are cases that have held that conduct-based immunity is immediately appealable under the collateral order doctrine.
Mr. Obermeyer, on this point, you have some burden when it comes to the jurisdiction question here and some burden when it comes to your assertion of immunity. Put aside the complaint and put aside the contract. Do you represent that Muzin was an agent of Qatar?
I don't know that I can represent anything beyond what's been alleged at this point, Your Honor.
So you can't represent that Stonington is an agent of Qatar?
They were acting as contractors for Qatar, sure.
That's not my question.
Right, they registered under FARA as agents of Qatar, yes.
So are you representing that they are agents of Qatar?
Yeah, they registered under FARA, they are agents of Qatar.
Okay.
And you have not requested an opportunity, if we were to look beyond the pleadings, an opportunity to establish the direction by Qatar in the district court. You never asked for that in the district court.
Your Honor, no, because again, Mr. Broidy was his burden to start was to plead an objection to the state's immunity. He pled that the objection comes down to the fact that the agents here are U.S. citizens. At that point, we're operating under the complaint, and Mr. Broidy's never really pushed back on that, Your Honor. I believe there was a request for 12B1 discovery, maybe in a footnote at the motion to dismiss stage. But going back to those quotes I read you from his own briefing, he has agreed with us that is what he's pleading, and that's what
our jurisdiction is not something that the two of you can agree on.
Well,
if there's any waiver here, the waiver is by Qatar, which, I mean, why shouldn't we just hold that, that the immunity emanates in one way or another from Qatar? It never has asserted anything in this case.
Well, Your Honor, this has been something that we need to get to. We've gotten sidetracked a little bit, but what Samantar said, what the Supreme Court said in Samantar is that in the absence of a statement of immunity, like the case here, it's not that the inquiry ends there. It's on the court to look to the established principles of the State Department and the common law to understand the agent's immunity. And that's what we're asking the court to do here. I mean, keep in mind, when the case was initially decided in California a couple years ago, the court found right away that Qatar was immune. You have the allegations in his own complaint that we're the agents of Qatar. So at that point, from a 12B1 perspective, there's no more to do. I mean, the pleading standard for him at that point is similar to a 12B6 standard. There's been no request for discovery, no further factual development, and that's the record. That's why your jurisdiction, I don't think, is affected by the fact that we're on the complaint.
But Qatar never communicated with the State Department to request a finding of immunity for these defendants, correct?
That's correct, Your Honor, but my response to that would be they had the ruling right away that they were immune. They had the allegations that we're acting at their direction. And if you look at the Heaney case from the Second Circuit, Judge Friendly, he says, in the absence of a statement of immunity, when you're talking about like the heart of political acts, diplomatic acts like you have here, the court doesn't need a statement of immunity to find jurisdiction. Or
Diplomatic.
I'm sorry,
What diplomatic acts are you talking about?
the ones that the Ninth Circuit said here, the hacking and distribution of hacked materials, the Ninth Circuit said are diplomatic activities of the sovereign. That the use of irregular operatives to hack an enemy and distribute those materials are, quote, uniquely sovereign.
To the extent they're engaged in by Qatar. But these laws, these statutes and the California law that was alleged they all apply also to private individuals who want to go in and hack. And for example, if your clients had done what they did and then turned around and offered their wares to Qatar, there would be no claim of immunity.
I think that's right, Your Honor, but that's not what happens here. I mean, there's no daylight between what Qatar is immune, the Ninth Circuit held Qatar is immune from doing, and what Mr. Broidy alleges we did. The state can only act through its agents. I mean, that's a sort of a fundamental proposition of foreign sovereign immunity that goes back, 200 years. The state can only act through its agents. The agents here, as alleged by Mr. Broidy, are appellants. And so what he's challenging, what a litigation of this case would be a judgment on how Qatar, A, decided to implement its diplomatic acts, as the Ninth Circuit said, and also it would be an adjudication of Qatar's decision to use U.S. agents to do that.
How would exercising jurisdiction here, how does the district court's order that it wants to exercise jurisdiction here have the effect of enforcing a rule of law against the state of Qatar? I don't see that. If the district court is careful about discovery and respecting Qatar's immunity, well, it can apply the domestic law to these individuals without any attention to the role of the state.
Well, two things, Your Honor. Respectfully, that standard is from the Restatement 66, which we contend is not the scope of conduct-based immunity in the common law. So when Lewis is talking about that, for instance, that's under the assumption that Section 66 is the scope of conduct-based immunity in common law. That's not what we're saying, so I want to be clear about that. But in this case, it's still even different than Lewis if you apply that, because in this case, the agents are doing what Qatar has been held to be immune to do. I said that correctly. But the actions that the agents are taking, they are the state when they're doing them, when they're directed by the state. And so this is where you sort of, it's not about the individuals. That's what conduct-based immunity is about, the immunity of the state. And again, that's a fundamental premise.
If you take the allegations as true of the complaint, would you agree with me they make out a criminal offense under federal law?
Honestly, I'm not a criminal lawyer, but it sounds criminal to me.
Yeah, and isn't it also true that an individual committing criminal offenses is not entitled to immunity?
Well, that's true, Your Honor, and in fact,
and then doesn't it follow then that if we accept the allegations in the complaint, as you have just agreed, making out a criminal offenses, there's no way that these individuals are entitled to immunity? Because if they were, then I think there's some indictments that have to be dismissed of some Russian hackers that occurred during the previous election, not this one.
Well, I think it's two separate. I'm not sure I'm entirely following, Your Honor, but I think it's two separate things. I mean, what we're saying here is that they are immune for the civil claims in this case. And, what's left are misappropriation of trade secrets, receipt of stolen property, and conspiracy for basically hacking. We're not saying there's immunity from criminal. And in fact, as we said in our briefs, I mean, the executive retains the authority in these cases to basically decide they're not going to recognize immunity here and pursue them criminally.
Why does it make sense if the same action would make out a criminal offense? It cannot be if they were indicted first and convicted, and then a civil case was brought. There's no possible way they could have immunity.
Well, I'm not sure, Your Honor, but why it makes sense, though, is because this is, you're in the province of the executives here, at least in terms of understanding foreign sovereign immunity. And so when the executive decides we're going to prosecute this case, they're making a judgment on foreign sovereign immunity. What you have here is you have another U.S. citizen, arguably with an agenda of his own, bringing a civil claim against other U.S. citizens, and that is that civil liability where the foreign sovereign is at the mercy of an individual bringing a case at the mercy of the courts. That's what is sort of at the heart of foreign sovereign immunity. And
put aside I'm not asking you now. I have one more question at least. Put aside the jurisdictional question, the appellate jurisdiction. Is it your position that every individual or company, I guess for that matter, that is registered under the Foreign Agents Registration Act has immunity for anything that it does in compliance with the wishes of the particular government that they're representing?
No, absolutely not, Your Honor. I mean, what I'm saying is something narrow. What I'm saying is that
but you said that because two of your clients at least registered under FARA, that shows that they're agents of Qatar. Well, and anything they do that Qatar asks them to do comes within the sphere of immunity.
But let me be clear, Your Honor. So I was asked a question by Judge Walker about outside of the complaint, are they agents? Having registered under FARA, they are agents of the foreign sovereign. Their FARA registration is not what we're saying is the scope of the agency for what happened in this case. What we're saying is the narrow point that because they were pled to have done what Qatar directed them, so it's not an issue of discretion, what they were directed to do, those are the same acts that Qatar has been held to be immune, for which Qatar is held to be immune. It has to be that the people, because the foreign sovereign acts through individuals, it has to be that they are immune too. There's no daylight between them and the individuals. And that's not a broad.
I don't follow that. So imagine you have, I mean, I understand the core cases, all the cases with, you can point out the exceptions to me, but most of these cases involve employees or officials of the state. And when we talk about a foreign official sovereign immunity, we're talking about people who have a relationship as the arm of the government that's immune. It's a very different situation where you have somebody that's hired to, sketch out a plan and maybe take action, and where, as appears, there's a disclaimer of an agency relationship in the contract, and to say that Qatar would be immune to the extent, assuming for purposes of the jurisdictional question, that Qatar would be immune for its action if it did this. Very different to say that individuals whose relationship to Qatar has only been pleaded and not established are entitled, based on that pleading, to immunity. I don't know of any case that goes nearly that far. Well,
Your Honor, I think you've got 5 cases where, and it starts with Butters, and I can go through them all, right? Where the fact that they're contractors, what was key was that they were directed to do what they did, not their status. And I think the issue is that this is not status-based immunity. This is conduct-based immunity. And if you look at the common law, if you look at what the State Department has said, if you look at the foreign sources that the State Department incorporates, it's clear that the fact that you're not an official in the sense that you're working under some sort of a status with a foreign government is not where you draw the line here. Agents of the foreign sovereign, those working at their direction, are entitled to that derivative immunity. It's conduct-based immunity as opposed to status. That's why I think thinking about them in terms of, those cases involve officials, that's not conduct-based immunity.
Your best case is Butters?
I think Butters is our best case, yeah, and Mariah, and also, Ivy, Rishikoff, Alikov, but fundamentally it's Butters, and I think Mariah is very helpful too. And to be clear about Mariah, I mean, the individual in that case, he was a former Israeli minister or something of some sort, official of some sort. But in that case, he was acting at the point when he was a U.S. resident, barred in New York, I think ahead of a New York hedge fund. And there was being in that case, well, and Mariah cited Butters favorably, and then in the Ben Haim statement of interest, Department of Justice cited Mariah favorably. So I think the principles in Butters are clear going back to case of Sinclair up through, recently Muzin in the Justice Department cited the case of Sinclair and Muzin just a few months ago.
And would you welcome an opportunity to establish as a factual matter in an evidentiary hearing on remand your client's role as agent in regard to the conduct alleged here, acting as agents of Qatar?
Well, I'm not sure. I mean, my concern is this is, I think, the sixth complaint filed by Mr. Broidy. I mean, this is what he's pleading. These arguments were raised in California. He hasn't at any point said that we went rogue, that we were doing something outside of Qatar's direction. What he says is we acted at Qatar's direction, and I think it goes to his whole theory doesn't make any sense if we're not acting at Qatar's direction. So I don't know what discovery would do at this point. I mean, I think this record is enough for your jurisdiction.
Is the Qatar's involvement is not? I mean, he's not going to in the end have to prove Qatar's involvement, right? I mean, there are violations here that have to do with hacking, getting into accounts that you're not supposed to have access to, doing so repeatedly. I mean, none of the law that supports the causes of action in this case require any involvement of any foreign government, right?
But his theory, Your Honor.
I understand his theory.
Yeah, I mean,
he may not get to do the discovery that he hopes to get about Qatar. I mean, people's motivation for suing is separate from what the law requires and what the claim rests on. I mean, you don't have any question that this case could proceed if Qatar tomorrow turned out to have been a fiction and never existed, could it? I mean, maybe Mr. Broidy wouldn't want to bring the case, but you could litigate this entire case if there's no such thing as Qatar in the world, right?
Only if everything about the case as it's been pled 6 times up until now is totally different.
Well, no. I'm talking about the factual elements that are alleged supporting the claims of violation of law.
I suppose, Your Honor, as a discrete point, but then the whole thing becomes different. It becomes, you have individuals who are doing something on their own to hurt Mr. Broidy, and the entire context of the case, everything about this, it's an entirely different case. The case that you have before you, and this was Mr. Broidy's choice to plead it this way, and to not ask for, 12B1 discovery, is that we were acting in Qatar's direction. So that's a record on appeal. I'm not sure if that affects your jurisdiction or affects the ability to make a decision here. And again, it's not like this is the first time Mr. Broidy's been here, meaning in court with these allegations. He's never at any point said anyone went rogue. In fact, Your Honor, the complaint, just one more point, he says after the initial hack, he went to Qatar and said to Qatar, and I could have to get the quote here for you, but can you direct defendants to stop, or are they rogue, or are there rogue agents? I mean, again, fundamentally, what this is about is that appellants were acting at Qatar's direction.
And I assume if this is remanded to the district court, that you will be objecting to any and all discovery into the involvement of Qatar.
Well, we didn't really talk about discovery yet, Your Honor, but I mean, I know what's happened so far and what's going to happen in the district court, which is Mr. Broidy will seek invasive discovery about what happened. In California, the way that manifested itself was that there was sort of an agreement to stay away from the parties, but at the time, for instance, Mr. Alaham was not a party. Discovery was taken. Qatar was in that case, of course, but they stepped in to protect under a protective order as highly confidential what the California court later referred to as the diplomatic communications of Qatar. And this was just one sort of discrete thing. They stepped in to claim immunity, or not immunity, sorry, sort of diplomatic privilege over phone records, over other things as well. What's going to happen here is if the case goes forward, Your Honor, I think you said this, it's going to be a document by document, witness by witness, scorched earth, sort of battle over what's Qatar's, what can it protect, And the reason that is, I think, I sort of fundamentally goes back to what I've been saying the whole time, is because the case is about Qatar.
You never sought to have the case dismissed for failure to join an indispensable party that could not be joined under Rule 19, did you?
We didn't in this case, Your Honor. It was Qatar requested it in California, and it was denied. And we were relying on the immunity decision here, Your Honor. And if you look at all these cases, I don't see many Rule 19 arguments. I mean, Rule 19 obviously brings in a few other factors, but fundamentally, also the California court had ruled against that.
Because Qatar was in the California case, so they didn't need to dismiss.
No, it was because even if they were immune, they may be necessary, but they weren't indispensable.
Can I ask a question about a statement you made in the district court that I think does not mean that you've waived the argument you're making, but I want to get some clarification on it. You said, this is at docket entry 41, page 12, defendants here assert derivative sovereign immunity, not foreign official immunity. And one way to read that is that you're kind of derivative sovereign immunity that Butters talked about, but you're not asserting conduct-based foreign official immunity like the kind that was at issue in Lewis. Is that what you were saying then?
I think that's in a footnote, right, Your Honor? I don't have it in front of me.
It is.
And I can't remember precisely what we were getting at then, other than Lewis had come out kind of in the middle of things and sort of shaken things up, and we were sort of figuring out where we were. But I would say we have not waived it. The point was merely we were trying to say, we were bringing a derivative sovereign immunity case at that point, and then we've since reacted to Lewis. But we have not waived it, Your Honor.
Can you just kind of give me a reason why a statement, defendants here are not asserting foreign official immunity, is not a waiver of your argument that you are now asserting foreign official immunity?
Two things, Your Honor. It was in a footnote, and as opposed to the text, and also in the reply, we were very clear that we were asserting under both.
Okay.
Is that because footnotes don't count?
Well, I guess it depends on the footnote, Your Honor, but
Justice Douglas in the dissent said that. He said footnotes don't count, complaining about the majority opinion. But he said it in a footnote.
I agree with that as well, Your Honor. The reason I'm hesitant is because I tend to use them as well, so I don't want to, feel a waiver about that down the road either. But
isn't it also an issue in terms of waiver, that the district court did go ahead and address foreign official immunity as well as derivative immunity? So in some sense, those issues are both before us.
Thank you, Your Honor. That's also a very good point, and it was before us. It was before you on that for that reason as well.
All right.
No further questions.
Further questions?
Not for me.
All right. Thank you, Mr. Omar. We'll give you a couple of minutes on rebuttal, even though we've way exceeded the time.
Thank you.
We'll hear now from Mr. Coffin.
Thank you, Your Honor. May it please the court, you can hear me okay? We have some
a little muffled, but yes, we can.
See if I can stand closer to this. Okay. Defendants are U.S. citizens and residents who claim two different forms of what they call foreign sovereign immunity for their involvement in this hack and smear scheme against another American on U.S. soil. Now, Judge Pillard, I want to just briefly on jurisdiction. Our argument on jurisdiction is that there is not a substantial public interest in these defendants being heard in this court at this point. And the reason is their entire argument is that there is a substantial interest in protecting Qatar. Qatar is not here. Qatar has not sought relief from the United States, and Qatar has done everything they can to disclaim association with the facts of this case. So it's very hard for me to see how there is a substantial public interest in protecting Qatar in this case when Qatar has done nothing to protect itself. On the merits,
but on, I mean, the collateral order doctrine doesn't look at substantial public interest. It just looks at whether there's an issue that's conclusively determined by the district court that is completely separate from the merits and would be effectively unreviewable on appeal. And yes, it has to be an important issue completely separate from the merits, but we typically, when we're looking at jurisdiction, we assume the party could prevail on its position and determine in that posture. And so if we assume that Mr. Obermeyer prevails on the, why doesn't that just resolve the jurisdictional question?
Well, first, substantial public interest is, with all respect, part of the analysis under Will v. Haddock. What they're saying is they want to avoid the right, they want the right to avoid a trial, but it's a right to avoid a trial that would imperil a substantial public interest. And the reason is that these defendants, these alleged agents of Qatar, private agents of Qatar, there's no substantial public interest in the timing of this appeal. They can bring that issue at the end of the case, and they can be protected if they are correct. They could be protected from liability at that point. But the right to avoid a trial, as opposed to the right to avoid a trial, doesn't imperil a substantial public interest as to these defendants, unlike the state itself, where there may be.
I'm still having trouble following how you're using that. I mean, as I understand it, the explanation about imperiling a substantial public interest is a very, it's a big basket describing why we have interlocutory appeals in cases involving the state immunity. And the protection of immunity at a very general level, that is the substantial public interest. We don't look and say, well, what about this case or this case? Is there
it's the kind of immunity? It's the kind of immunity, Your Honor. It's the and yeah, there's a bit of a merits here, but the immunity as to non-public agents of a foreign sovereign. I mean, part of this is simply these guys just don't merit immunity, and it bleeds into the merits in some regard. And of course, we filed a motion to dismiss the appeal to try to avoid the time of the appeal. So in some sense, we're here on the merits, and I'm happy to talk about the merits. I don't want to get too dragged down in jurisdiction because I think the merits are incredibly strong for our side, and you know, I'd like to move to them. But that's I hope I got my position.
No, I mean, that makes more sense to me. There is always some sort of merits consideration. If somebody, you know, if I'm sued by my neighbor because my tree is overshadowing hers, I can't just say, well, like Italy made me do it and have an interlocutory appeal.
Right.
So you know, you're always looking at some level at the type of merits claim, and that to me that makes more sense than looking more specifically at public interest with respect to, you know, the facts of the case.
Correct.
Yeah, that's helpful.
So look, on the merits, Your Honor, this, and I think the parties agree that Samantar and Hoffman, and even going back to Schooner Exchange, the inquiry on the merits is this two-step analysis that Samantar discusses. On step one, whether Qatar, the foreign state, has asked for immunity, they have not. Nor have they, as Mr. Obermeyer said, nor have they gone to the State Department in any way to seek the United States intervention here. As a matter of fact, Judge Pillard, in the Ninth Circuit, or in the Central District of California, the Qatar actually opposed going to the State Department. They said this is a judicial issue, and you don't have to go to the State Department. Early on, we had said, let's ask, and both defendants said no. You don't have to ask, and you can dismiss that case on other grounds. The lack of Qatari involvement in this case does frame this case.
Now,
well, but Mr. Coffin, I mean, it would be helpful to have you address directly the core of Mr. Obermeyer's contention, which is this is at 12b1. It's a motion to dismiss. It's based on the complaint, the allegations of the complaint, again and again, talk about the defendants acting at the behest of Qatar. Why don't we take your word for it on this point in terms of analyzing the immunity?
So the State Department doesn't take just the allegations of the complaint, and this court has never just looked at the allegations of the complaint. But that said, I want to talk about the allegations of the complaint a little bit. We have
tell me what your best authorities are when you say the State Department and this court don't just look at the allegations of the complaint.
Well, so this court I'm going to quote Judge Sentel, which is my favorite thing to do, being a former Judge Sentel clerk. Bell House versus Yalin. Bell House involved allegations of some official act. This was under the FSIA. And Judge Sentel said, we still want to look at the facts. We have an obligation to satisfy ourselves with the facts. And so they looked at the question of official action in that case, notwithstanding the allegations of the complaint. And state has said, look, even when the foreign sovereign tells us something is in an official capacity, we're still going to satisfy ourselves of that. And they've said that, Judge, I mean, there are a number of briefs where that we filed. We have a supplemental addendum in this case. That has most. We thought that would be helpful to you here, given that they're not always easy to find. And in that addendum, I mean, state repeatedly says it's our determination, with the input of the foreign state that matters. As to the allegations of the complaint, we certainly say they're the agents of the foreign sovereign because they're registered under FARA. The question is, did this occur in any official capacity? I want to back up for a minute, Judge, before I get into that factual question, because agent, the question of, is there an established policy of the United States recognizing immunity under the circumstances here? Step 2 of the salmon tar analysis. There is not a single authority that deals with a pure contracting agent. The best case for Mr. Obermeyer is in Sinclair, the 1797 Attorney General opinion, but that's under a commission. That is a commissioned privateer under a formal commission recognized under international law to give the protection of the state to the commissioned ship and captain who can't be arrested for piracy and the like under international law. When there is no authority for pure contracting agents, the entire body and the scarce body of law that deals with official immunity is just what you said, Judge Pillard. Officials. That is, the vast majority of these cases involve someone who has an employment relationship and even an appointed or an elected relationship with the state. That is usually high-ranking officials, sometimes just employees, but within the formal structure of the government. And
so much, Mr. Coffin, I'm sorry to interrupt, but so much is done by governments around the world through contracts that used to be done by employees. And I guess my precise question is, we don't have a State Department statement of interest here. We don't have Qatar coming in and asking for a position. But if we were to say, I mean, is the best way to resolve this case to rely on the burden? There hasn't been a showing that there's an established State Department position. But if the State Department wanted to develop one, nothing that we say would foreclose that.
That's right. That's right. On the agency point,
right.
I think it would be an arrogation of judicial power, with all due respect to my friends on the bench, to try to fill a gap here. The common law. So, my favorite quote in all of this case, Judge Randolph, you're not going to be surprised, is your statement in your separate opinion in Lewis, where you say, it may be that there is and never has been a common law of foreign official immunity. I think that's right here in two respects. First, the respect that you said, which is there's just not that much law. There's just not enough of a body of law for us to look at and decide what the standards are. But second, and this is really critical, there is no common law in a classic sense of common law judge-made gap filling. What the entire focus of this inquiry is what would state say? What is the State Department's, what is the position of the United States? And Hoffman, going back to 1949, Hoffman says courts shouldn't be making it up one way or the other. It's just as bad for a court to try to fill a gap where state wouldn't provide immunity as to do the opposite. And so
when you refer to common law, you mean State Department common law.
That's what common law is in this limited context. The substantive law that Hoffman says applies here is what would state do, right? And what you're looking for is an established policy. Now, as to agency, there simply aren't established policies that extend immunity to contracting agents. And what I would say is, if you go back to Underhill, the Second Circuit's opinion that led to the active state doctrine in the late 1800s, what that court talked about was immunity for the official representatives of the state. What other courts have talked about are acknowledged and embraced agents, are the authorized and ratified acts of those agents. Going back as far as the first statement by the executive branch, the Attorney General 1794 opinion in Suits Against Foreigners, which is at 1 Op. Attorney General 45. This is the Guadalupe governor case. If the seizure of a vessel by the governor in that case is admitted by the foreign state to be an official act, well, then immunity might apply. What we're talking about in all of these cases, to the extent agency matters, is avowed agents. That is, the foreign state says, these are our actions, which is exactly what happened in the Southern District of New York case, the Mariah case. Israel came in and said, this guy who was our former official is still kind of acting, doing black ops for us on the side. They put in an affidavit to that effect. These are avowed agents. That's point one. I don't have to win on that point to win this case, though, because even if you assume agency, what the United States said in USCA is that residency, it matters. That is, even if you assume a foreign official who was acting within the scope of their official capacity, because a foreign official in USCA v. Samantar had moved to the United States and was resident in the United States at the time of the suit, the United States said a major principle in not extending immunity to that foreign official is that they are a resident of the United States. Here
and that's kind of essentially reciprocity. They're subject to our law. They benefit from our law.
It's a principle of U.S. sovereignty, right? That's what the United States said is, we recognize as an international law principle in USCA that immunity of the official exists for the benefit of the state. We recognize that. Nonetheless, and that's the key word in the USCA statement of amicus, nonetheless, where there is a binding tie to the United States for the particular defendant, that is, where they're a resident, that the United States says there's no immunity. Now, Mr. Obermeyer says, yeah, but there was no established government there. And that was the other principle on which the non-immunity determination rested in that case. Well, if you look at the subsequent history of that case, as we lay out in our brief, when there was a recognized government and the United States met with that government and that government said we're not going to assert immunity, the U.S. said, well, residence then matters. We still stand by our original non-immunity determination. So this case really is on all fours. That is, while there wasn't, it's not a case of a government that doesn't exist, but we have a government that's standing on the sidelines. Government who hasn't gone to the State Department, hasn't asked for immunity, and we have U.S. residents who are claiming immunity on their behalf. That principle alone we win on.
So, Mr. Coffin, I do want your help just circling back in light of your argument to the appellate jurisdiction question. On the one hand, just because if a court's going to find that there is no immunity, that is separate from, that doesn't defeat jurisdiction. I mean, we know that from Arba and a whole line of...
I'll take that, Judge.
I understand, but we're trying to get it right. I mean, that's our job. And so in some sense, it seems like the first case presenting a particular kind of fact scenario, like a non-official, non-employee, non-avowed or claimed private contractor, it seems like, well, there's an immunity issue bound up in there because there's an immunity claim. And then it seems like after, if we were to so hold, then it would become clear there is no immunity there, therefore no, leg up to the Court of Appeals for purposes of a collateral order appeal. But that seems like that can't be right, that the question, the first impression aspect of the question can't be the ticket to the Court of Appeals that then is used up.
Well, I guess the question is there's a separate question that Judge Katz has asked in the API case. Is how colorable is the claim? Now, if you get that.
You're talking about the Nigeria case?
Yeah, the Nigeria case. This is last year's case. APNI, I believe. Attorney, something process.
PSID, Process and Industrial Development Corporation.
Thank you.
Yeah.
There's a separate inquiry of colorability. We actually don't think these are colorable claims given the lack of Cutter's involvement here. And that layers on top of the collateral order analysis, and we think we could win on that. But if you say, well, it's debatable, it's colorable, we still think that the nature of an assertion by a mere agent of a foreign sovereign who has nothing but a contractual relationship with the foreign country just doesn't rise to the level of a substantial public interest, which I see not your favorite argument, but that's our position.
They do have allegations of direction by Cutter, but.
No, Your Honor, let me speak to that for a second. We have not alleged, what we have alleged is that, and this is, I think we've alleged very clearly, we have alleged that Mr. Muzin identified Elliott Broidy as a problem that needed to be dealt with. These defendants were deciding which packets of information went to which newspapers. That's our allegation. The direction, we have not alleged direction by Cutter. We've alleged that this stuff has been done on behalf of and in complicity with Cutter, but we've alleged that these guys have had an enormous amount of discretion into how to carry out this plan. Go after Elliott Broidy, if that's a direction, okay, maybe, but even there, it was Mr. Muzin that said we have to go after Elliott Broidy. So factually speaking, I don't buy into the notion that our complaint alleged direction. Yes, it did allege that these guys were FARA agents. It alleged that they acted, in complicity.
Excuse me. Yeah. I want your comment, and I'll ask Mr. Overmeyer the same question. To this statement as a general rule, that is for non-official, non-foreign government officials claiming to be agents of the foreign government, that a necessary, although not necessarily conclusive, requirement for any assertion of immunity is that the foreign government communicates to the State Department that it's invoking on behalf of these individuals its immunity.
Your Honor, I mean, that's a predicate to our position. I mean, I think that's absolutely correct. Absent Cutter's avowal, absent Cutter's ownership of these acts, I mean, yes, they were FARA agents.
And the reason I formulate it that way is that one of the things that we're trying to do, and this argument back and forth really reflects it, is to see what impact either giving immunity or not giving immunity would have on the foreign relations of the United States with the country at issue. And you really can't know that. I mean, we're just guessing, and we're trying to make up some rule of law that weeds out the cases that don't have an impact from the cases that do. But the easiest way to do that is just make it a prerequisite that the foreign government has to communicate to the State Department on behalf of the individuals. And if the government doesn't, they don't get immunity.
So when Your Honor, when there is, I agree with that. What state has said is when there are officials, okay, when there's someone who's the president or defense minister, state will apply a presumption that their acts are official, and then they'll try to confirm it. But you
exactly.
Can't do that.
That's why I framed up in terms of non-official foreign officials. We're talking not about
the key
officials.
distinction between officials and agents here is you can't do that absent avowal by the foreign.
Right. My only hesitation, I'd like your response to what if Mr. Overmeyer's clients had a contract that said in terms, you know, we believe that in this activity you're acting as our agents, including for purposes of any immunity that might be claimed. And, you know, I mean, for example, then the government changes and wants to disavow what the prior government did, would seem like there would still at least be a question whether they were in pari materia with employees of a former regime that were treated presumptively as acting on the state's behalf.
And of course, you know this is a counterfactual hypothetical because you yourself have said that the agreement said just the opposite. But you're suggesting, well, there might be some objective evidence outside the state. But I think for the reason that Judge Randolph is suggesting, there's no you just can't know what the foreign affairs implication is when the state isn't stepping up. But again, under either standard, whether it's you have to go to state or you have to look for objective evidence outside of just the use of the word agent in a complaint, you don't get there here. There is no avowal. These are black ops, right? I mean, what state is going to come into a court and say, yes, these guys were our hackers and they were doing all of this on our behalf? They want plausible deniability, but there's a price to that, and the United States judge understands that. I mean, the one thing I take issue with the Ninth Circuit on, or one of the many things I take issue with the Ninth Circuit on, despite the fact that two of the judges were my colleagues in the Justice Department, but despite the thing that I would take issue with Judge Collins on in the Ninth Circuit is the notion that there's going to be some major international implications to holding Cutter responsible. Certainly, let's put Cutter out of the picture, but as to the agents, absent avowal, there's just the state continues to maintain plausible deniability. And as to these covert operations, every state, including the United States, understands that if their operatives are caught in a foreign state, those operatives are basically on their own. I mean, the CIA does what it can behind the scenes to bring them, to get them back. But the United States operates at its own risk in covert operations overseas.
Right.
And so the reciprocity is just not as compelling here.
Judge Walker, do you have any other questions? Judge Randolph?
None for me.
All right.
Thank
Thank you, Mr. Coffin. We've gone way over time, and Mr. Overmeyer will give you a couple of extra minutes.
Thanks, Your Honor. I will be brief. First of all, I want to just make clear something that I said earlier with respect to agents in response to a question of Judge Walker. And it's related to something that Mr. Coffin said. The complaint alleges that they are FARA agents, and the complaint also alleges that they had lawful contracts where they were doing lawful activities, and then it turned into something, well, whatever he says, I think it's more sinister or something like that. So I just want to be clear, like with respect to FARA, we're talking about the contract that was registered and going forward. So I want to be clear about that. It doesn't change anything though with respect to.
So let me ask about that, because I thought that your answer was clear when you gave it, but then I thought you maybe backed off of it a little bit later in response to some other questions. So maybe I can think of a more precise way to ask the question. With regard to context of this case, are each of the four defendants, are you representing that each of the four defendants are agents of Qatar?
I guess the answer, Your Honor, I don't mean to be evasive, is it depends as to what. I mean, with respect to what was registered under FARA and the lobbying work they were doing, they were agents of Qatar. What has been alleged is that they were also agents in a hacking conspiracy. And that allegation of direction, and I can talk about Mr. Coffin's direction comment, that is distinct, but it still gets you to the same place.
I think the complaint alleges that at least some of the defendants were not registered under FARA for the entire time. Do you represent that for the entire time in question, each of the defendants were agents of Qatar?
Your Honor, I don't remember the specific timing of the FARA registrations for all of appellants. But I agree that the complaint mentioned something about that. I don't know the specific dates.
I mean, regardless of whether anyone was registered under FARA or not, maybe I'll give this one more shot. Do you represent that each of the defendants were agents of Qatar?
For purposes of the lawful actions they took, they are alleged to have been agents of Qatar to participate in a conspiracy to hack and distribute material.
That's going back to what's alleged in the complaint. With regard to the time period in question, with regard to the time period that's covered by the complaint, and without regard to whether they were registered under FARA or not, do you represent that each of the defendants was an agent of Qatar?
Yes, but what I'm trying to say, Your Honor, is just that I just wanted to be clear that I'm not saying that we agree with the allegations that they were agents. That's all I'm trying to get. I apologize if I'm being obtuse or too talkative about it.
I'm not asking you to admit that they did everything that's in the complaint, but I do think that it's hard for you to assert foreign sovereign immunity without representing as a necessary but not sufficient argument that with regard to the time period in question, each of the defendants were agents of Qatar.
I don't disagree with you, Your Honor. FARA sort of adds complications, and then I wanted to make sure, to your point, I was clear about what I was saying on behalf of my clients. That's all. But I don't disagree with what you said, Your Honor, on that point at all.
Okay. Thank you.
The next thing I wanted to,
over time, unless one of my colleagues has
sorry, Your Honor.
has a question.
Well, I'd just like Mr. Overmeyer's comment on the statement of a legal principle that I asked Mr. Coffin about.
Well, Your Honor, I'm sure you won't be surprised that I disagree with the principle. And I disagree with it because, what Samantar says, the Supreme Court has said that, the statement of immunity is not the sine qua non of immunity, of foreign sovereign immunity.
Well, that's under the FISA, that's true. And as far as federal or foreign officials, that may be true. But we're not talking about either one of those categories of people. We're talking about people who are even more remote. In other words, contractual agents.
But Your Honor, that's where I disagree with you respectfully, because the established policy, the common law, is that it's not the status, it's not them as officials, it's that agents of the foreign sovereign are entitled for immunity for actions directed by the foreign sovereign. That goes back, I think Mr. Coffey mentioned it, case of St. Clair. It goes back to a Twigros, a UK decision that has been cited favorably by the State Department. And I just would.
What about Mr. Coffin's point that these aren't actions directed by the sovereign, even on the allegations of the complaint alone, which says you hired these people, or you hired these, Qatar hired these people, and they decided in their discretion how to carry out the general remit, and this precise means and the precise targeting was not the directive of Qatar.
Two things, Your Honor. First of all, I already read this, but this is from page 9 of their opposition to interlocutory appeal, where Broidy says that he, quote, alleges that defendants acted at Qatar's direction, end quote. So
generally, he doesn't deny that. Generally, acted at Qatar's direction.
But what's key for derivative immunity is that what he has alleged they were directed to do is what is the basis for the alleged liability. He says that he alleges that he directed them to disseminate materials.
All right, do some great press for me. I hope you find dirt. Discredit this guy. See you later. And if I did that to my intern, I'm a newspaper editor. I do this to my intern. Go find some, and the intern goes and commits criminal activity. Surely,
I don't disagree.
Run. I mean, that's a bad example because it's not a government or immunity example. But chief of police says to officer, go do X and so. There's no defense of following orders there.
I don't think I disagree with anything you're saying, Your Honor. But what I'm saying here is that what's alleged to have been directed is the conduct that establishes liability. So in Butters, the conduct was don't hire the woman because she's a woman.
Right.
The claim was Title VII. That's the level of specificity.
Right.
Here, the specificity is disseminate hacked materials. That he decides to do it to the Wall Street Journal and not the Washington Post or whatever it is he alleges happened, that's besides the point, because what forms the basis of liability is the direction to conspire to hack and disseminate.
Other questions?
No.
Thank you very much, counsel. That was well and informatively argued. The case is submitted.
Thank you very much, Your Honor.
This honorable court is now adjourned until Wednesday, March 3rd at 9:30 a.m.
Goodbye.